So, my lords, getting into the argument on the hours clause, there are a significant number of contextual points I want to make. Let me start with the language of the clause itself, which is at tab 9 of the core bundle, page 155. And my lord, condition, I mean, just noting condition 1, the reinsuring condition, which is obviously integral, in consideration of the payment of premiums subject to the terms and conditions, etc. The reinsurers agree to indemnify the reinsured up to the limits in excess of the deductibles on account of each and every capital L loss, capital O occurrence, which may be sustained under the business specified in class, etc. And then condition 2, definition of loss occurrence. 2.1, the term loss occurrence shall mean all individual losses arising out of and directly occasioned by one catastrophe. And at this stage, the argument, we've got a catastrophe, and as I've submitted to your lordship and wasn't conceded, we've got causation. This is a construct for the purposes of the reinsurance. A loss occurrence is used for the purposes of excess and limits, and clause 2.1, condition 2.1, tells you what it is. It means all individual losses arising out of and directly occasioned by one catastrophe. What condition 2.2 then does is it provides for the duration and extent of that construct. The duration and extent of any loss occurrence, so defined, shall be limited to ... and then we can go through the various subparagraphs. And the punchline, halfway down 156, after Roman 7, and no individual loss from whatever insured peril which occurs outside these periods or areas shall be included in that loss occurrence. My lords, I'll come on to the practical examples of this and the context and things like that in a moment, but as a matter of language and simply dealing with it purely as a matter of language, condition 2.1, condition 2.2, sorry, does not say the duration and extent of any individual loss shall be limited to ... Even if one writes out in longhand, as your lordships were invited to by my learned friend, the duration and extent of all individual losses arising out of and directly occasioned by one catastrophe. And I don't accept, in fact, that's really the right way of doing it. But even if one wrote them out in that way, that would still not say the duration and extent of any individual loss comprising that loss occurrence shall be limited to. It is a construct which defines the duration, temporal, extent, geographical, of the relevant loss occurrence. And in my submission, what the hours clause therefore requires you to do is to identify whether an individual loss falls within or without the relevant period, or perhaps for riots the relevant territory. But it does not tell you, even as a matter of strict language, that you should, as it were, apportion or divide individual losses into different parts, different sections, themselves into different periods of time. And the tribunal at paragraph 91 in my submission got this entirely right. This is the supplementary one. Page 27. Page 27, sorry. Paragraph 91. they accepted our submission, as Covéa points out, paragraph 91, page 27. As Covéa points out, the hours clause limits the extent and duration of a loss occurrence by permitting aggregation only of individual losses that occur within selected periods of a set number of hours. Crucially, however, the hours clause does not operate by limiting the duration or extent of any such individual loss. It is the duration and extent of a loss occurrence so defined that condition 2 limits, not the duration and extent of any individual loss that occurs within a loss occurrence period. And they say the same thing at paragraph 97 in the first sentence on page 29. As previously noted, first sentence of 97, page 29, as previously noted, condition 2.2 limits the duration and extent of a loss occurrence, not by limiting the recoverable indemnity available for any particular individual loss, which falls within the ambit of a loss occurrence, but by confining aggregation of such losses for the purpose of applying the reinsurance deductible solely to those losses that occur within the selected period of hours applicable to the perils in question. There is nothing in the reinsurance wording to support an apportionment of an individual loss. Specifically, there's nothing in the reinsurance wording to support the contention that an individual loss that occurs within a designated period of hours but continues to be sustained thereafter is to be apportioned with the object of indemnifying only that portion of the loss sustained during the applicable number of hours. And then they go on to the expert evidence, which I'll come back to in a moment, but I'm simply focusing on the language of this for a moment.
So just looking at it in terms of, trying to sort of flesh on bones, as it were, what you say is the loss occurrence runs from, in the example we were talking about earlier, 23rd to 30th of March,
yes,
2020, and it picks up all individual losses which have commenced
yes,
during that 7-day period.
absolutely. And if it,
not known constat that they go on for 3 months or 6 months or
absolutely,
whatever.
absolutely.
Once they're within the loss occurrence, they're then covered.
Indeed so. And I'll come on to explain how that works for property damage, for BI consequent on property damage, and for the facts of this case. But absolutely so. So what the hours clause is saying is, and I'll take the classic hurricane strike. Hurricane strikes somewhere in the Caribbean on day 1, somewhere in Louisiana or Carolina, wherever on day, take 5, day 6, but outside the window, those are 2 different individual losses to 2 different properties, one on day 1, one on day 5, 6, 7, whatever it is. And that is the purpose of this hours clause. In other words, I agree with my learned friend, it's always been common ground. The object of the hours clause is you have to ascribe a date and, if necessary, a time to an individual loss to see whether it falls within or without. But the key question is, when does that loss occur? And I'll go on to make the submission in a moment that, as a matter of this contract, as a matter of reinsurance principle, well familiar to your lordships, some of your lordships, I imagine, and other contextual matters, the answer to that is the answer the arbitrators gave and Mr. Justice Foxton gave. But purely focusing on the language of this and treating this for the moment as a textual point, because obviously my learned friend invited you to effectively write in the terms of 2.1 into the opening words of 2.2. Even then, textually, it doesn't say the duration and extent of any individual loss, which makes up a loss occurrence, is to be limited in the appropriate periods of hours. But your lordship anticipates where I'm going with this.
Yeah.
The judge, for your lordship's note, paragraph 147, agreed with the arbitrator's analysis on this point, which I've just shown you. So the judgment 147, the reference to that is tab 5, and it's page 114. Have I got the right reference? Just hoping that's the right reference. Yes, 147, the judge said, further, a second sentence, as the Covéa Tribunal noted, the hours clause defines the extent of duration of a loss occurrence, not the duration of an individual loss. Same point. There's nothing in the clause which requires you to, as it were, scissor and paste, cut up, slice and dice, as I say sometimes, an individual loss. Now, my lords, that is, in my submission, entirely consistent, both with the more general provisions of this reinsurance and reinsurance and insurance principle more generally. That is to say, when you're asked to identify for insurance or reinsurance purposes in a losses occurring during policy, which is what this is, it is almost axiomatic that you're seeking to identify when that loss first occurred. Almost axiomatic. And that is so even if the loss is a continuing one, and even if the financial losses arising therefrom are also continuing, which is very likely to be the case in a BI context, but may well also be the case in a pure property damage context as well. The fact that
the classic case in which one comes across that principle is professional indemnity insurance, isn't it?
Yeah. I mean, that's likely to be, generally speaking, on a claims made basis, I anticipate. But it's the same principle. What partly underlies all the case law on this, and you get into grip of the peril principles, the Knight and Fane, is which policy is.
Well, the point I've got in mind is that once you've triggered the cover, you don't look at how long the loss goes on for. That's the point I've got.
Absolutely so. And that's one of the reasons that drives that, of course, is that once the peril is struck and you're suffering financial loss, maybe continuing property damage, maybe continuing business interruption, you're not going to be covered under the next year's policy, for example. It's fundamental to those principles. So, my lord,
but defining it as when the peril strikes, or as when business interruption starts, are two separate points of time.
I agree with that, my lord.
Would you say that in the example we've been looking at, where the school would have been closed anyway, there is no business interruption when the peril strikes?
Well, on our facts, there was an interference with business when all the schools were ordered to close from close of business on the Friday. Now, and that is so whether some of the nurseries opened on Saturdays, as some of them do, whether they didn't open until Monday, or whether perhaps some of them were not going to. I can't remember the school holidays and when Easter fell, but let's say some of them.
It doesn't really matter.
Doesn't really matter. But
in a case in which, at the moment that the closure is made, the school was already shut down for the first week of its 3-week holidays.
Yes. Now, I'm going to submit to your lordship. I'm going to answer your lordship's questions as you.
Sorry, I probably shouldn't say weeks because we need to get some days in. But you have the point I'm making.
But I do, and it is obviously possible to envisage a case where a business has been closed, is closed at the time it strikes, isn't going to be reopened for a month, 3 months, whatever it is, where it could be said on the particular facts there has been no interference, business interference. Forget the financial losses suffered as a result of that business.
No business interruption.
But no business interruption. No.
What we're concerned with.
I mean, that would mean effectively that you weren't envisaging contractors going in or teachers going in to do work in school in the meantime. It might envisage that there's no loss of advanced sales for when you're due to reopen, all sorts of questions like that. But I certainly wouldn't eliminate the possibility of a particular factual case where a business, whether it was closed for months because the people had gone on holiday to Australia for 3 months, and the order of the Prime Minister didn't in fact pose any interference at all to that business. Now, if those were the facts, then I can see the argument, frankly, that there's been no individual loss because there's been no interference with that business. So, but my lord, just to follow that through, that doesn't answer the question of construction that you're being asked to deal with, because let's suppose for the sake of argument, the business only was due to reopen on the 1st of April, and factually there was no interference with that before the 1st of April. Just assume that. When it reopens on the 1st of April, it can't because of the orders and the pandemic from the 18th, 20th of March. No reason on this example to say anymore, well, maybe you fall into a different loss occurrence window, but it doesn't mean you then have to slice and dice the continuing loss for that from that start date, even though it'd be a later start date.
I understand that. What I was just trying to seek to clarify is that when you talk about when the loss occurs, distinguishing it from the financial quantification of the loss, you seem to assume that was always when the peril occurred.
No,
I think your submission is
the interference one.
It's when the business is interrupted.
Yes, because I can answer your Lordship's question now by reference to the FCA test case, just to pick this up. And my submission is it's the interruption or interference, using those words analogously, which is the analogue, the counterpart to the physical damage, if we're just looking at property damage. So you have insured peril hurricane causing property damage. Mm-hmm. Insured peril in this case, which is, trying to remember it, the emergency likely to endanger life, leading to government instructions to close, which leads to an interruption with the business. Just going back to it goes back to the precise peril, which is set out in the award, and it is at paragraph. Just give me a moment. It is at paragraph 37 on page 12. So the peril, reading backwards, paragraph 37, page 12, is an emergency likely to endanger life or property, causing, and that's the words following on, I'm going backwards, of course, my lords, the actions or advice of government or local authority, causing access to the premises being hindered or prevented, causing an interruption of or interference with the childcare business. Now, the peril, looking at that, is the emergency likely to endanger life or property, requiring the actions or advice of government, requiring access to the premises to be hindered or prevented. The interruption of or interference with the childcare business is the analogue of the damage, which you would otherwise have in a more simple case where, for example, an insured peril causes damage. So it's not enough, and I'm not saying, my lord, it's enough for there to be a peril. There has to be an individual loss. And the individual loss is either, in a simple case, when the property is damaged by the hurricane, or when there is the interruption or interference with business. My case on the facts is, and this isn't a question of law for your lordships, however much one wants to try and go behind the facts on this, but it's not a question of law for your lordships, is that on the 20th of March, with effect from close of business, all these insured premises were ordered to close, and that was an interference or an interruption with their business. And of course, on the individual facts, which are not in the award, it's possible that some sat on Saturdays, it's possible that some didn't sit till Mondays, and so forth. But for the purposes of our case, there was a relevant interruption or interference in the findings of the arbitrators, and the arbitration had been conducted on this basis from the closure on the 20th, approximately caused by the outbreak.
Presumably with the physical damage, you are financially worse off from the start. There is a financial loss from the start. You say the analogue is interruption or interference, and you say that's regardless of whether, in any sense, that renders you financially worse off?
Well, if the answer, it is the analogue. I'll show your lordship what was said in the test case on that. Clearly, if in fact the closure didn't cause any financial loss to the nursery, there would never be any inwards business interruption loss which was settled by Covéa at all, because the way that business interruption works, I mean, suppose the nursery had suffered a fire before the 20th of March and was going to take 6 months for repair anyway. it's a hypothetical, isn't it, with respect to my own friend's argument, because there wouldn't be a claim. You compare the standard turnover with and without, you adjust for special circumstances, and you never get an inwards claim, which would come up the line to the reinsurance. But that, I'm not sure that
No, I
completely
do
answers.
follow how you put it, but you could contrive a set of facts which affects timing.
Yeah.
You've had your fire, you're going to reopen on the Monday. Have you suffered a loss on the Friday because there's in some sense an interference with your access to the premises? Well, there is an interference with your access to the premises. Or does the loss suffer on the Monday when actually you would have been charging something?
Well, my lord, if I may respectfully distinguish between charging something and when you were going to reopen, because there's a possible middle ground inherent, I think, in your lordship's question to me. So we have the order saying everyone must close. We have, now my submission in answer to your lordship's question is that is an immediate interference with the business. That is an immediate, no one, clear out, no one can go back in.
Irrespective of whether you suffer any financial loss.
That's a different question. I agree that's a different question. Clearly that's going to be relevant to whether there's an insured claim and therefore whether there's a reinsured claim. And my inference says, well, the indemnity principle and so forth. I'm not suggesting for one moment that there's going to be a financial claim on some theoretical jurisprudential basis that my theoretical property rights have been interfered with. I mean, that's not the way that business interruption works. As your lordships may recall, I'm sure you compare standard turnover with actual turnover in a period which is often a 12 months period. If there's no financial consequences, then that's not going to give rise to an issue. But picking up my lord's point, so you've got the interference immediate on the 20th, to which my primary submission would be yes, that is the analogue to the damage. The separate question would be, well, is that enough, or do you actually need to show that you would in fact reopen, that you weren't closed for the weekend? To which the arbitration hasn't been conducted on that basis, but that is moot, because in a sense, even if the effect of a decision that it depends on whether the nurseries were going to reopen on a Saturday or a Monday, if that really had to be built into the inquiry, you'd be within the same 168-hour loss window anyway, loss occurrence window anyway.
But analytically, I think it does matter to your argument as to whether financial loss is to be equated with business interruption. Because as I understand your argument, it is the financial calculation of the loss, which may take place over a period of time, is not for these purposes when the loss occurs.
That's certainly what it is.
And if we're trying to look at what's meant by the second half of that, when the loss occurs, one point at which it might occur is when the peril strikes. One point at which it might occur is when there is interference with the business, which may be when it was closed anyway, but it's still being interfered with. Or it may be when you first suffer some financial loss that goes with both of those, some financial loss.
I see that.
And is your case the third of those?
No.
So
it
is your case that you don't have to have suffered a financial loss in order first to have suffered a loss under the original assurance?
If the question is, my lord, that there will at the end of the day have to have been a financial. So what one's dealing with the timing of what on any view will be a financial loss, because otherwise it's academic. But in asking the question, when does an individual loss occur? The answer to that, so it's a timing question, and the answer to that in my submission is not dependent upon the accounting practices or the books or the invoicing or whatever it is of the particular underlying insured. Just as, I mean, it might be possible to envisage, although it's less easy to envisage, property damage which, for whatever reason, because everyone's away, the business is closed anyway for other reasons, but this nonetheless eclipses what's gone before. Might be possible that there's no immediate financial loss in a property damage case either, in an accounting sense, in your pocket sense. And so my submission to your lordship is that the analogue is the property damage. It is the interruption with the business. The way that business interruption claims will then be adjusted is that you will look at a period of time, as Mr. Justice Foxton said, well, in fact, in the first week of the time, maybe not, I mean, suppose hypothetically everyone's already paid for next term, you weren't going to get any more revenue in for the next week. It's not until when you view it over an entirety of the week of the year with ups and downs, credits and debits, that you see what the loss is. But you date it back to a moment in time when that first interruption occurred. That is my submission, Your Lordship. And that's the
and it's an interruption which need not have any immediate financial consequences. Yes. So that in the example which Mr. Christie, I think, was giving of a case in which at no stage during the 1 week of the relevant period that's being looked at is there any financial loss because it was always going to be closed. Nevertheless, the business interruption, you say to you, takes place the moment there's a closure order, and therefore it doesn't matter if the first financial loss is 2, 3, 4 months later.
There's a closure order which interrupts or interferes with the business in the sense that that business has been closed as a result. I do accept...
That is your case.
Yes, but to be very clear, I would accept the possibility that if it wasn't closed as a result of the order because the business was already closed, that you haven't necessarily got the interference with the business, which is the analogue of the damage. Where I'm making clear, I hope, what my case is, it's not necessary to have suffered a financial loss in the sense that you've actually got to go to the accounts and show that if you took a snapshot of your accounts, financial accounts, for the 168 hours after the interference, it's not necessary to prove the financial loss within that window.
Can you have an interference without a financial loss? I think you're saying you can.
Well, my lord, it depends how one approaches this, and it may be that one's, as it were, at a theoretical level. I mean, if everyone has paid in advance for the term, and there's no question of getting credits back, then it may be that you haven't actually suffered a financial loss until you've carried the calculation forward for the indemnity period, which is 3 months. And you can say that interference on such and such a date, with effect from the 20th of March, has caused me, looking at the indemnity period, comparing it with the equivalent period back, a financial loss. And for relevant purposes, my lord, the question is, well, when did the individual loss occur? And Mr. Christie's case is, as I understand it, well, if you have peaks and troughs of your revenue stream or your expense stream, and because you've already been paid up front for the term or whatever it is, you don't actually have any interruption with your revenue stream for that week. You then do for 2 weeks, but then you don't for another week. Every week has to be viewed at separately. And I'll come back to this, but that's simply not how business interruption insurance works, and not how any reasonable reinsurer, knowing that he was covering catastrophes which might give rise to business interruption loss, would expect it to work. So I'm not...
Sorry, go on.
No. Well, I hope I answered my lord's question to explain how I put the case.
Can I just think round your semi-concession one moment, that it might matter if the business were already closed, and then you say, well, perhaps there wouldn't be an interference. I mean, there would still, in strict terms, be an interference with the owner's rights.
Yes.
They couldn't go into the property. If you're right that loss occurs as soon as there is an interference, regardless of a financial consequence, I mean, why wouldn't that also be a loss? You'd have the interference with the right to go into the property and do what you wanted with it.
Well, my lord, this is the trouble in debating with respect what might be very fact-specific questions on in individual examples. The reality is a bit like the closure orders in other parts of the retail industry or the entertainment industry and the like. Orders were made, premises were closed, key workers apart perhaps. And to try and disentangle the closure order from an interference which operates in any event, whether the owner wanted to take advantage of access or use of the premises on the Saturday or the Monday or not, is a really artificial dividing line. So I want to be careful. I mean, I've tried to at least concede the possibility, without conceding it applies on the facts of this case, and without conceding it may apply in many cases, that it is theoretically possible, perhaps, for the interference on a particular business in a factual sense, not a financial sense, but a factual sense, only to have happened at a later stage. But that's not this case, and this arbitration has been conducted on the basis that all these schools, nurseries, were closed from a date certain and close of business on a Friday. So in a sense, my lord, it's a theoretical concession, which I find, with respect, only likely to arise on quite particular and extreme facts. Because most businesses, I mean, I think in our skeleton we gave examples of, depends on the audience's particular interest, but one can imagine cricket grounds like Lord's or music festivals like Glyndebourne being ordered to close, in the sense that access being denied from 20th of March. Whether or not the owners of those premises are proposing to go in and use them before the cricket season or the opera season starts, it's not really the right question in my submission, and particularly whether they've suffered immediate financial loss is not the right question either. But Mods, can I just make good the point I was making by reference to the test case, which is paragraph 215. The submission I was making is that the interference is the analogue of the damage. And this is paragraph 215 in the test case at page 84.
So sorry, which paragraph?
Sorry, but 215. And they're there dealing with the Hiscox clause in the previous paragraph. And I just cite this for this reason. The Supreme Court said this: the first of these causal links between financial losses and an interruption to the policyholder's activities is of less significance than the others. That is because, although the FCA has suggested otherwise, we think it clear that the interruption is not part of the description of insured peril. The concept of business interruption insurance of this kind was, in our view, correctly analysed by Mr. Simon Salzida QD in his submissions on behalf of Argenta. It's a description of the type of loss or damage covered by the policy, in the same way as the type of loss or damage covered by, for example, a building insurance policy is physical destruction or damage. Thus, in a building insurance policy, unless the policy otherwise provides, the insurer is liable for the contractual measure of destruction of or physical damage to insured buildings, which is proximately called by a peril insured against under the policy, such as fire, storm, etc. In business interruption insurance, an interruption to the policyholder's business or activities is the counterpart to the first of these elements, describes the nature of the harms to the policyholder's interest and the subject matter of insurance, for which an indemnity is given if it's proximately caused by insured peril. And that passage was picked up by and commented on in a bit more detail in Mr. Justice Foxton's judgment in paragraph, let me just give the original reference. I'll give the original reference in a moment.
Sorry? Paragraph?
Sorry, I'm just trying to find it quickly. Forgive me 1 second. I think 130, I'm told. Thank you very much. Yes, considered in more detail at 130, pages 106 to 107. Thank you very much. So, my lords, what we say is that the focus on when an individual loss first occurs is not just consistent with losses occurring during policies generally, it's also consistent with the other provisions of this reinsurance. So, for example, my lords, if we look at the reinstatement provision on page 152 of tab 9, so this is the loss occurring reinstatement, and over the page 153, losses hereunder are applied chronologically by date of loss. That's the third paragraph from page 153. Reinstatement would be done on a first occurring basis. It wouldn't be done on a slicing and dicing and saying, well, you had a continuing loss and parts of your property damage worsened over time, parts of your business interruption continued over time, let alone that financial losses resulting from it continued over time. It's just not the way that reinstatement would work.
No.
My learned friend referred your lordships to condition 3, the extended expiration. And he suggested that the clause would be otiate on our construction. My lords, we don't accept that with respect. If this contract should expire or be terminated, while a loss occurrence covered by this contract is in progress, it's understood and agreed that subject to the other terms and conditions of this contract, the reinsurers hereon are responsible as if the entire loss or damage had occurred prior to the expiration or termination of this contract, provided that no part of that loss occurrence is claimed against any renewal or replacement of this contract. My lord, what that is primarily dealing with, certainly dealing with on my submission, apart from the fact that it might be making plain that any post-expiry loss was intended to be covered, is it's addressing the question of what happens while a loss occurrence is in progress. So what that means, my lords, is if the policy expires during the 120 consecutive hours of the hurricane, or the 504 consecutive hours of the flood, so for sake of argument, one has a loss to property A on day 1, policy expires on day 2, hurricane strikes another property on day 3. There could be no argument that the loss, the individual loss to property, the second property on day 3, form part of the same loss occurrence, even though the policy had since expired. It's wrong to say that that is otiose as a matter of construction. It's there perfectly standard in an LOD context, dealing with the temporal scope of individual losses once a policy has expired.
So just going back to the reinstatement clause.
Thank you.
Is your submission that the expression losses hereunder applied chronologically by date of loss, in order to be operative, means that for the purposes of this reinsurance, any continuing loss must be treated as having a single date of loss? Because otherwise you wouldn't be able to apply it chronologically.
Yes.
Is that your submission?
Well, it is. I mean, we're talking about the same individual, we're talking about the dating of individual losses.
Yes.
And it is, the way reinstatement works in my submission is that one has to ascribe a date to an individual loss, not has that individual loss extended for a period of time and part of its continuation, as it were, has come after a new individual loss second in time. That's not the way reinstatement works. And indeed, the last sentence does allow a certain latitude in making collections and so forth before you necessarily know everything about things. But that is my submission. Yes.
But if your loss, although a continuing loss, is a periodic loss that can be identified as being suffered at particular dates, your fees are payable weekly, whatever it may be, or daily, or even hourly, so that you can say, I suffer this loss of income each hour. Why does that prevent you from treating each hour as the date of loss in order to apply the clause chronologically.
The trouble with that, my lord, is that one would have to effectively slice and dice an underlying settlement of a business interruption loss.
You often have to do that with excess of loss reinsurance treaties because they're written on different terms.
Well, they may be, my lord, but
that's not of itself an objection, is it?
The arguments on practicality go down are coming later, if I might say so. It is a remarkable submission, in my submission, that one disregards the practical reality of how business interruption insurance losses are settled or adjusted before they are settled. Because the way they are adjusted and the way they're settled, and there are follow the settlements clauses, and there are UNL clauses in this reinsurance, as you would expect, which require the reinsurers to follow the settlements, which entitle the reinsurer to recover all the sums actually paid in settlement, and so forth. It's quite striking that the submission is that at reinstatement, you would have to, as it were, take every 168 hours of the continuing financial loss and reorder or rank the chronological happening of the losses accordingly. Could it theoretically be done, my lord? Well, if that's the answer to the question.
You don't have to do it because there's the option to do it in settlement date. So actually, on this particular clause, it's perfectly workable from a practical point of view.
It's just not the way it would be done in general, but so be it, my lord. My lords, still on the order of, still on the losses occurring during approach to matters, my lord, the Chancellor has already referred to, in effect, perhaps without saying it, to the Knight and Faith principles, Wasser and Lexington principles, that post-expiry continuation of an ongoing loss falls within the scope of cover. Forget clause 3 for a moment, but that is axiomatic. We've given references to that at page 60 of our skeleton argument, footnote 47, Wasser and Lexington to municipal and mutual. And my lords, we'd also draw attention to the various eateries jurisprudence. Again, I'll give your lordships the references to this to save time, but in various eateries, paragraphs 67 to 69, and in Stone, which is tab 4, page 217, and in Stonegate, paragraphs 69 to 73, that's tab 3, 156. I'm happy to take your lordships to these if you find it helpful. Basically, what comes out of these cases is that if there's an enforced closure within the period of cover, there's a single trigger, which is the enforced closure, irrespective of how long it continues for. And the insured can recover the full extent of its proximately caused losses, even if the closure extends beyond the policy period.
Which paragraph is that in Stonegate?
So in Stonegate, my lords, it is 69 to 73 at page 156. So 69, halfway, a third of the way down page 156. I don't accept Stonegate's case, there would have been multiple triggers. In the case of insured location, which once closed stayed closed, but where the closure was enforced by the reiteration, continuation, or renewal of regulations, it triggers the enforced closure, and in my view, there'll be one such trigger, unless until the location opens and is then closed again. And I don't want to take time up reading this, but 73 is the punchline again. I should also add that in keeping with the submission of Allianz in the BE action, I consider that the number of covered events, the number of occasions on which there were materially different restrictions imposed or advised and so forth, steps taken or advice given, which merely repeated or renewed, would in my view form part of one existing set or part of one set of actions or advice. But just going to various eateries, just tab 4 quickly, that is paragraph 67 and onwards at 217, page 217. So the argument is under the head of prevention of access and enforced closure, and your lordship will see the argument of Allianz at 64 Allianz contended that the policy provides there should be an indemnity only for BI as a result of enforced closure or prevention of access during the period of insurance, and that there's no cover for any period of enforced closure or prevention of access after the end of the period of insurance, even though the closure or prevention may have begun within the period of insurance. And then 67, the judge says, I don't consider that Allianz's argument is correct. In my view, the correct construction of the policy is that the covered event, in the case of enforced closure, there's an enforced closure in an insured location within the period of insurance, i.e. if the closure takes place within the period of insurance. There could then be recovery for the resulting interruption and interference of the business, and the extent of that interruption or interference would depend on how long the closure lasted, irrespective of whether the whole period of such closure was within or after the period of insurance. Similarly, in relation to prevention of access.
Is there anything in the Court of Appeal that bears
Yes,
on
there is, my lords. It is at paragraphs 93 to 5, tab 5, 252. And it's paragraphs 93 to 5. The Lord Justice Mayles at 252 sets out the judge's view and the judge's comment of paradoxical results, and cites paragraph 69 of Mr. Justice Butcher's first instance judgment in various eateries. And then Lord Justice Mayles says this: short point of construction, I agree with the judge. The function of the insuring clauses is to identify the covered events under the policy. The relevant covered event is a prevention of access or an enforced closure occurring during the period of insurance, that is to say between 29th September 19 and 28th September 20. A prevention or enforced closure occurring on 1st of September is such a covered event. Because it occurs during the period of insurance, accordingly VE is entitled to recover the business interruption loss proximately caused by that covered event, even if that loss extends beyond the period of insurance, subject only to long stop and the maximum indemnity period in the policy schedule, and so forth. And then paragraph 95 is the punchline, really, the conclusion. Allianz agrees to pay the business interruption loss proximately caused by a covered event which occurs during the period of insurance. The business interruption insurance loss which it agrees to pay is the reduction in turnover caused by the covered event, beginning on the day of the covered event and continuing for a maximum of 12 or 24 hours. So, necessarily, therefore, the losses which VE is entitled to recover may continue beyond the end of the period of insurance. Now, my lords, I accept this is dealing with the inwards position. I don't want to, this is as such.
But it's also dealing with the moment or period at which the insured peril occurs rather than the loss occurs, isn't it?
It's dealing with the trigger of the coverage of the policy for the purpose of coverage.
For the insured peril. Closure here was the insured peril, and
yes,
the question was whether you treated that as a continuing peril, as it were, so that it didn't only happen when the closure occurred, but was a state of affairs, as it were, so that you could say, well, actually, you haven't got your insured peril, i.e. closure, inside the indemnity period, if it remains closed after the expiry of the covered period. That was the issue, as I understand
that was the issue, and it's not dealing. Of course, it's not dealing.
So
with
I understand you say it's analogous, but it's not quite the same.
No, I am accepting.
It's insured peril rather than loss.
I am accepting it's analogous, but one's got to stand back and think what's being contended for here. What's being contended for by my learned friend, and he was upfront about this. It is that the financial losses consequent upon an enforced closure or prevention of access, at least at the reinsurance level, not at the insurance level, because of the way business interruption is worked, I'll come on to that in a moment, have to be divided up into 168 hours or 72 hours, as the case may be, sections. And that is not consistent. Indeed, it's fundamentally inconsistent with the way in which business interruption insurance works, which is, at least in part, the subject matter of this reinsurance. We're past the stage now, I think, at this stage of the argument, where catastrophe having been accepted, business interruption losses, including non-property damage interruption losses, fall within the scope of the reinsurance, as would be known by any reasonable reinsurer, and are capable of giving rise to a catastrophe causing losses which would potentially breach the deductible. So we're past that stage, and it is, I rely on these COVID cases, albeit at the inwards level, because they demonstrate how the inwards coverage works. And they demonstrate, for the purposes of identifying the time at which an individual loss occurs, that it cannot be directed towards the moment at which financial losses are or are not suffered on a 7 days of credit, 7 days of debit, 7 days of credit basis. That's just not how it's done. If one asks for the reinsurance, it being common ground that the relevant question for condition 2.2 is when do the individual losses in inwards underlying insurance occur. Mr. Justice Butcher's answer, the Court of Appeal's answer, would be that the loss occurs, at least on the face of it, at least absent particularly extraordinary, I'd say extraordinary, but particular facts, the loss would occur on the enforced closure. And I take my Lord's point that the focus was on trigger, the focus was on the chronological scope of cover, and so it's analogous.
Are these cases saying that's when the loss occurs, or that's when the insured peril occurs?
They're saying when the insured peril occurs, but they are also going further than that, my Lord, and saying continuing interruption and continuing financial loss from that interruption is tied back to that original moment, and that's where it becomes more directly analogous. My Lords, can I, I've dealt with, as it were, the textual language of the clause. Can I then deal with the practice of dealing with property damage losses, business interruption losses consequent on property damage, and the consequences of how that's dealt with for pure non-property damage business interruption losses? My Lord, the first thing to say is that if you imagine a case which involves property damage but no business interruption at all, for whatever reason, either perhaps there's no insurance taken out for business interruption, or for whatever reason, perhaps the business was already suffering damage, not as bad as the subsequent damage, but it was closed for anterior reasons. So there's plenty of possibilities where you might have a PD-only claim. And my Lords, it is common ground. It's set out in the award at paragraph 98, which is page 29. Paragraph 98, page 29. The arbitrators say, in the case of physical damage to property, Unipol accepts that a loss that occurs within a loss occurrence period, but is aggravated thereafter by the impact of the same catastrophe, is recoverable as in full as falling within the same loss occurrence. Unipol cites as one such example an earthquake that damages a dam, where the damage worsens over time, eventually leading to its collapse in consequence of the initial structural damage. Another example cited by Unipol Re is where a flood damages the foundations of a home, causing it to collapse in stages, both before and after the end of the relevant loss occurrence period. Yeah. Now, obviously that's not what we're dealing with here, because we haven't got property damage, but one does have to ask about the consequences of my own friend's submission in the light of this concession, because the reason why that concession was made perfectly correctly in my submission is that if a hurricane or a flood strikes a building on day one, and that is when the relevant individual loss occurred, first occurred but occurred, without any subsequent strike of either that or a different peril, and in an unbroken chain of causation, if there is subsequent physical damage which arose as a result of the initial strike, that would be treated on normal principles, death blow, grip of the peril, even apart from policy terms, that would be treated as part of the same loss. Chronological purposes, chronological ranking for reinstatement purposes, all that sort of thing. If my own friend is right on his case on business interruption or non-property damage business interruption, it's very difficult to see why the collapse which happens 14 days later, 2 months later, 6 months later, in an unbroken chain of causation, and gives rise to additional financial loss, does not constitute a separate loss occurrence for the purposes of dating. It's difficult, if not impossible, to see on his argument why the same principle doesn't apply. And he does not confront that for the purposes of his argument. Moving on to the next stage, this is business interruption following on from, caused as a result of or related to the property damage itself. The hurricane strikes the factory, 6 months of repairs required, 6 months of business interruption resulted. My lords, it is no part of my case, and it wasn't part of my case, that there was some sort of binding custom which somehow, pursuant to an implied term, mandates the solution to the case. It's never been part of my case. But the long-standing market practice, going back many years, was and is that the business interruption, albeit continuing, is treated as occurring at the same time as the property damage and as part of the same underlying loss. And the arbitrators recorded the undisputed fact of that. You don't need to go to it, it's paragraph 26, Roman 4, on page 10. It's also in the award at paragraph 97, page 29. And the judge referred to it at paragraph 113. Now, I don't say that's a binding practice, but it's been a practice against which these parties contracted. And therefore, as the arbitrators themselves said at paragraph 97, page 29, in the last sentence of paragraph 7, last sentence of paragraph 97, page 29, the fact that market practice is contrary to Unipol's analysis, but is in compliance with Covéa's, suggests that Covéa's analysis makes more commercial and practical sense. Now, as I say, I don't push this to the extent that it mandates the answer, but on normal constructional principles, the parties have contracted against the background of this long-standing practice. And there is no logical distinction, in my submission, between the treatment of business interruption losses consequent upon property damage and business interruption losses consequent upon a peril which doesn't involve property damage. Mr. Justice Butcher, again, I accept my lord dealing with a different point, observed in various eateries at paragraph 69 that it would be paradoxical, his words, for the cover to respond in a markedly different manner depending upon whether there was fire damage or POA peril or the like. So we say that the way in which the market deals with business interruption losses in circumstances of property damage is directly relevant to inform the way in which the parties to this contract would have understood its provisions to apply. No higher than that, but it's very relevant context, we say. And my lords, I have already made the point, I think, that the wider contractual context is antagonistic to the suggested apportionment of an individual loss into different 168-hour windows for a continuing interference or a continuing financial loss if one moves to that stage of the argument. It is simply not how the inwards business works. And again, I say, without in any way trying to treat this as some sort of stop-loss reinsurance. That's never been our case. Of course it's not. Without any way trespassing on AXA and Field, which is dealing with something completely different, we say that it is relevant, indeed not just relevant, but highly relevant, if not determinative, that the inwards business, which is the subject matter of the reinsurance, and to which one is directly pointed by the inquiry into when an individual loss occurs, treats the individual loss at the inwards level without apportioning for continuing periods of interference or continuing financial losses. And I've made that point. My lord, my learned friend makes AXA and Field points at really stage one of the argument on catastrophe rather than the as clause part of his case. But to deal with AXA and Field, it is clear that what Lord Muster was dealing with in that case was the submission by a reinsured that the different aggregating provisions before him, then, originating cause or event, should somehow be construed back to back. My lords, at the catastrophe stage of the argument, it's never been my case that they should be construed back to back. The reverse is the case, as your lordship will appreciate at the catastrophe stage of the argument. It's actually my own friend at the catastrophe stage of the argument who's been trying to subvert Lord Muster's decision by rewriting catastrophe as per occurrence, per event, when clearly the parties have used different language. But at this stage of the argument, AXA and Field is not authority for the proposition that one cannot use the subject matter of the inwards insurance, the way in which the inwards insurance would be known by any party in the market to be operated. AXA and Field is not authority for the proposition that that part of the background cannot be used to inform or interpret the reinsurance. And to cite it for that proposition is, in my submission, heterodox. My lords, I think I've answered, I hope I've answered, or at least I hope I've given your lordships my answer to the vacationing business point. I say, standing back and dealing with our nursery care losses, and to repeat, the closure on all these nurseries took effect from the 20th of March, pursuant to the orders of the government. The arbitration has not sought to distinguish or analyse whether particular nurseries were due to open on the Saturday, the Monday, the following week. The arbitration has rightly proceeded on the basis that the order of the government closed the nurseries, and that is effectively sufficient for these purposes, in the sense that a factual inquiry into individual nurseries has not been necessary. But for reasons I've already addressed you on, absent special facts, I would suggest that that is sufficient for the purposes of each of those nurseries to have suffered an individual loss. And in a sense, that is what the arbitrators and the arbitration award has so concluded. The arbitrators proceeding on the basis of causation have held and given the answer that they have. Paragraph 102 of their award at page 30 concludes by saying, this being the positional causation, that's the admitted positional causation, the tribunal concludes that interruption to the business of an insured nursery that occurred with its closure on 20th of March and continued until it was allowed to reopen as the first lockdown restrictions were lifted, comprised one individual loss within the meaning of condition 2. In my submission. it's difficult to see how there is an error of law as such in that conclusion, even if it was said that one wanted to dwell back into the facts and look at each individual nursery in a different case.
So the problem we were wrestling with simply doesn't arise on the findings, because the finding is that this is the position where there is interruption to the business
That's the premise.
occurring with its closure.
That is yes, and the arbitration conducted on that basis, and it's impossible to go behind one or two. My lord, I do need finally though to deal with the Markel Award, which obviously is before your lordships in a slightly historically strange sense. We don't have the pleasure of Mr. Kendrick to tease on the mismatch between the award
Indeed, Mr. Crane, who's
We will look forward to deciding the same point both ways.
Yeah. I have combination of Mr. Crane having to dance on the head of a pin and Mr. Kendrick having to explain how he persuaded them to reach a different conclusion to the one he was arguing for.
Indeed.
There we are.
I mean, it's a forensic point.
Get our pleasures where we can, really.
It's not just a forensic point to say that Mr. Crane, who was on both tribunals, and obviously we weren't aware at the time of arguing the case what the Markel Award had decided already. We weren't, but Mr. Crane, with respect, having heard the argument in our case, reached the conclusion he did in the Covéa.
Yeah, I mean, this award was actually 6 months later.
Indeed. And one of the points that we make, in fairness to the Markel Tribunal, because our submission is they went wrong on the as clause. But one of the points that, in fairness, one should make is that the arguments were different in Markel. They were different on catastrophe, but for the purposes of this discussion, they were also different on the as clause, because the submission that is recorded in the award, and if Miss Sabanclair was here, she would no doubt reiterate the submission she made to Mr. Justice Foxton, which was that she made the alternative submission. But the submission that appears in the award, and which is dealt with in the award, is that the only relevant question was whether the individual loss was caused by the operation of the peril within the relevant window. And the judge gave the example, I believe it was, try and find it. He gave the example that where this point would make a difference is, for example, if the Prime Minister said on the 18th of March, nurseries in London must close on the 20th, nurseries in the north of England maybe should close on the 27th, just giving that as an example. And as the judge said, on Miss Sabanclair's submission, that causation was the key. That might link a later closure, a staggered closure, into the same loss occurrence window. Whereas on my submission, the individual loss has to occur within the window, and therefore the second loss or second losses could not be aggregated. It's paragraph 133 is the example that the judge gives. So in fairness to the Markel Tribunal, a different primary argument and different argument in the award. But my lords, turning to the analysis, which is at page 55 of tab 4 of the supplemental bundle, where they say the issue is whether the business interruption losses were limited to those which occurred hour by hour within the periods prescribed.
Sorry, which paragraph?
I'm sorry, my lord, 57, page
57,
55.
yeah, thank you.
55. And in the next paragraph they say this: it is natural to think that business interruption losses occur day by day as the business interruption continues. But Genry's acceptance that in the case of physical damage, all consequential business interruption is not only caused but also occurs and is sustained on day one throws the matter into greater uncertainty. And you know, after all, once a business is closed by a catastrophe, even without physical damage, it's easy or at any rate possible to predict, as in the case of physical damage, what the likely consequences are in terms of business interruption subject to mitigation. And then 59, that said, however, it is easy to see that loss by reason of physical damage occurs when the physical damage occurs, even if it were to manifest itself only later, while business interruption, that is to say the economic loss of an interrupted business, as distinct from the physical loss of damaged premises, seems naturally to occur as time progresses. Now, my lords, picking up that language, and this is an award which does not address the submission that we advanced before the Covéa tribunal as accepted by the judge, which is that the key question is to identify when the individual loss occurs, which is what I've been addressing on. But putting that to one side, this analysis, in my respectful submission, conflates the interruption with the economic loss of an interrupted business. And of course, my own friend likewise conflates the two. In my submission, the fact that the economic loss of an interrupted business may be suffered, I prefer to use that word suffered as opposed to use the word occur for the sake of the argument. The fact that the economic loss of an interrupted business may continue over time and outside the loss occurrence window is not to the point. And it could equally be said, just as it's possible to envisage, that the economic loss of a physically damaged business can also occur as time progresses. Paying of loss adjusters, paying of contractors, paying doing temporary repairs, doing permanent repairs, let alone putting to one side the prospect of additional damage occurring in the natural course of things as the dam collapses or whatever. So in my submission, of course we recognise, and the arbitrators recognise that there may be factual differences between a business which suffers property damage and a business which suffers business interruption loss not consequential on property damage. And as the arbitrators say, it may be more important to be careful with causation to make sure that there's no break in the chain of causation. But my lords, the conflating of the financial or economic loss of the interrupted business with the interruption itself is, in my submission, the flaw in the Markel Award. And the Markel Award, as I have already pointed out, does not grapple with the submissions that I've been making to the Lordships or some of the losses occurring during analysis, the COVID analogies at first instance and in the Court of Appeal. Obviously various eateries wasn't out at this time and so forth. So my lords, we don't have an appeal before your Lordships on the Markel Award. But obviously your Lordships know about it. Mr. Justice Foxton has referred to it. Our own friend's perfectly entitled to draw it in aid. But we say that, with respect, that is the central advice. And had they received the submission or had it been argued in the same way, Mr. Crane at least has set out in his award in the Covéa case what he believes the conclusion is on the basis of the submission that I have advanced. My lords, I obviously took the first issue very shortly, but so far as catastrophe is concerned, you really have my submissions, and we've expounded on that in greater detail in writing. Those are the submissions I wanted to make on the House clause. We say that the arbitrators are right.
And the other thing to say about the Markel Award is that as matters currently stand, it's been overruled by Mr. Justice Foxton. And that's how matters stand.
That's how matters stand.
That's how matters stand.
That's how matters stand. But I accept that there is reasoning from a...
There's a limited scope. I mean, obviously, what Mr. Christie says is, well, he's only overruled it because he was wrong in the Covéa Award. But therefore, it might be said, well, the 2 points stand or fall together, but I'm not sure how much assistance one really gets from the Markel Award.
No, well, your lordships are aware there's another tribunal who reached a conclusion different to the Covéa tribunal. I'm not saying I'm not saying your lordships should blind yourselves to that reality, but no appeal, and insofar as it is necessary for me to say so, insofar as the reasoning is adopted, it's with respect wrong.
Yeah.
So, my lords, those are my submissions, and I say without repeating myself, I do accept the possible juridical distinction between the peril striking the property, which is the language the arbitrators used, and whether there is an interruption with the business. But in fact, on paragraph 102, interruption is set out in black and white.
You say that's a causation question which is closed off by the terms in which the award was framed.
I do. I mean, if in all subsequent arbitrations we've got to go away and look at the diaries of each nursery or business, then that would be disappointing, I suspect, to those that have to do it.
Well, as you pointed out, it's not just nurseries. I mean, we're actually we're treating nurseries as the paradigm source of the claim, but there's inwards business which isn't nursery.
So my lords, subject to pointing out that the football analogy that my own friend gave about Manchester City losing the FA Cup was not the catastrophe that I had in mind. It was winning the Premier League. But I was conscious that I am precluded, I think, from Mr. Justice Foxton.
As you know that would appeal to me.
Well, I was going to say, my lord, that I'm precluded from.
I don't know, all these Arsenal fans around the corner.
Mr. Justice, just finally, my lords, if you were giving Mr. Justice Foxton, when he gave his definition of, and forgive the flippancy, but definition of catastrophe at 104, Roman 4, 98. A catastrophe will involve an adverse change on a significant scale from that which preceded it. That would have made that particular submission rather difficult. But my lords, unless I can help further.
Thank you very much.
My lords, on the catastrophe issue, you've had my oral submissions. You've also got our written submissions of that. I'm not going to add to anything I said there. Purely that we say a catastrophe cannot be a state of affairs. It's a species of event, and there is an error of law in the judgment by the arbitrators and in the judgment in mixing up a state of affairs with an event that is not purely an evaluative exercise. On the R's clause, in some ways, and I think I said this in my submissions earlier, Mr. Schaff and I are just looking at this issue of individual loss or losses from two different ends of the telescope. And it may be that this tribunal has to decide who's looking at it from the correct end. Our position is that what the reinsurance is covering is financial losses. That is what reinsurers are interested in. They are allocating financial losses to the loss windows which have been prescribed in the R's clause. So there's a distinction between the losses and the peril insured against. And as I understand Mr. Schaff's position, you correct me if I'm wrong with that although there may be some exceptions, the individual loss is incurred when the peril strikes the business. Now we say our position is correct, because if you are dealing with losses, you are dealing with indemnifiable losses, and that is what the R's clause is dealing with. Now significantly, Mr. Schaff didn't engage with two provisions of the R's clause, which we say are extremely important. The final sentence of condition 2, and no individual loss from whatever insured peril which occurs outside these periods or areas shall be included in the loss occurrence. Now,
Well, he did. He did.
well, he engages with
He
it.
relied upon that provision specifically. It's just that he, picking up your telescope point.
Yes, point, yes.
He looks at it in a different way. He says, well, if I'm right, then this supports my case. And you say, well, if I'm
Well,
right, it supports my case.
I didn't pick up that particular part, but we say, I mean, it reflects then the original point which I made. We are coming at it from completely different perspectives. But he doesn't, as I understand it, again, I'll be corrected, the concluding in condition 2.4.2, no loss occurrence commences earlier than the date and time of the happening of the first
Sorry, which one?
recorded. This is page 157. The happening of the first recorded individual loss. Now, he may be saying that that is the individual loss, but we say that wording is actually consistent only with our analysis of financial loss and is referring to indemnifiable financial loss.
So if he's right, as I understand what this clause says is, you can split it into different loss occurrence periods. You can choose when they start, but one of the fetters on that is you can't choose a period that starts before one of the losses you're going to put into it.
Yes.
And that applies, as it seems to me, can apply equally well on either side's construction. On his construction, the losses that can be put into the period are losses which are determined by when the date by which they first occur. I think on his case that would give content to 442, wouldn't it?
Well, it's the wording, the happening of the first recorded individual loss to the reinsured. We say that's consistent only with the incurring of financial loss by the reinsured. It's not merely with the occurrence of the peril.
Well, that's the difference between you.
Yes, exactly.
Yeah, I mean, it's not.
I mean, the difference between you is that's the meaning of loss.
Yes.
I mean, I think
Precisely.
none of these provisions really takes the matter any further. And on one view, as my lord says, whoever's right, this provision, one can make sense of this provision.
Yes. But also, well, you've got my submissions in relation to the indemnifiable loss point there. I needn't repeat them. We say there is little to no assistance to be drawn from the passages which my learned friend referred to in various eateries and Stonegate. Those are dealing with the position at the direct level, and they're governed by the operation of the indemnity period and the provisions for indemnity so long as the business is affected. And so they've got no impact whatsoever in relation to the issue which is before your lordships. My lords, given that we are, I mean, the battle lines are drawn up in relation to the point, and you have my arguments in relation to that. And so, in response, I don't think I need to say anything further.
No, thank you. Thank you very much. Right, well, thank you all very much for with counsel and solicitors, because I know it's always a team effort, for the excellent submissions that we've received today. Obviously, we're going to reserve our judgment. You will not get a judgment this term, I can say with confidence, but we'll obviously get it to you in draft as soon as we possibly can. When you get it in draft, please, please pay attention to the terms of the embargo at the top of the judgment, and also the purpose of giving it to you in draft is so you can point out any typographical or similar errors, not to invite the court to reconsider its decision. But as I say, we'll get something to you as soon as we can, and if it's necessary to have consequential submissions, could they be dealt with in writing so far as possible? Thank you very much.
Court rises able.